Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about pre-trial custody credit. Cases that should have gone to the Supreme Court of Canada, but didn't. Diamond Sky Caribou brought a constitutional challenge in Manitoba to the 1.541 custody rules in relation to sentencing. These rules state that for every day that you're in pretrial custody before sentencing in your case, you get credit for a day and a half worth of time. Caribou argued that they should get a longer period of pre-sentence custody credit and that it was unconstitutional to limit it at 1.5 days. The court dismissed the constitutional challenge, arguing that the sentence in Caribou's case was not demonstrably unfit and therefore there was no basis for the constitutional challenge. But the court also commented that the constitutional challenge should have had expert evidence about parole eligibility and eligibility for remission or statutory release to try and support why the sentence would be demonstrably unfit in the circumstances, even though some of these things are already set out in provisions of the criminal code. And this case raises very important issues. The ideas of our right to reasonable bail is something that is currently under attack in Canadian law. And because the bail system is being reformed, and there is the possibility that in bail reform there are going to be more people who are denied release pending the outcome of their cases, the need for the court to consider these important issues that arise about giving credit becomes all the more significant right now. The Supreme Court of Canada could have had an opportunity to head off what is likely going to be a number of significant challenges related to the bail system and new bail laws that are being brought into place by determining that there is an unconstitutionality in limiting the amount of pretrial custody credit that a person can be given. Unfortunately, the Supreme Court of Canada didn't see the significance of this issue in relation to the current legal landscape, and it's going to take another case and people who are denied sufficient credit potentially for their time spent in custody prior to their trials and prior to their sentencings before the court has the opportunity to hear this case. Thank you for tuning in. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.